Accessing reliable childcare in the United States is already challenging, and the under- and unemployment of military spouses create a system where it's kind of assumed the non-military spouse will stay at home with any children. A divorce throws that arrangement out of equilibrium, and the potential lack of family support wherever someone gets stationed can lead to some creative solutions. Petty Officer Nicholas Rivet solved that problem by moving his girlfriend and her 2 children in. What he didn't account for was how the tight living arrangement would try the children's sleep schedules and his patience. This is Conduct Unbecoming. I'm Erin, and I'm your host. Before we get started today, I want to flag for you, Legal Beagles, that today's case discusses violence against a child. The victim was just 2 years old. So if this isn't the case for you, all good. Catch me on the next one. In or around 2001, Nicholas James Rivet enlisted in the Navy. He was originally from Louisiana, and over the course of his time in the Navy, he was stationed in England, in Virginia, in Jacksonville, Florida, aboard the USS Thomas S. Gates, and aboard the USS Simpson. Some of the sailors he worked with described him as the best leading petty officer they'd ever served with. He was, by all appearances, well liked by his colleagues, and had a wide system of support. Nevertheless, in 2009, Petty Officer Rivet separated from his wife. He was struggling to balance life and work, and needed help looking after his 2 children. So, soon after he began dating Brandy Robb, Brandy and her children moved in. Brandy was also separated from her husband and had 2 sons, Eddie, her youngest, and Logan. Brandy wasn't working and found it difficult to support her children financially. She and the boys bounced around with family and friends while they tried to find their footing, though things became more challenging when her car was repossessed. But Brandy and Rivet moving in together helped spread the resources they had just a little bit further. Brandy took over childcare at the house, and Rivet went to work on the USS Simpson at Naval Station Mayport in Jacksonville, Florida. To make this arrangement work, Brandy borrowed Rivet's car to run errands, to drive the children around, and to drive Rivet to and from work. However, Rivet was still married, and having a romantic relationship before his divorce was final looks a whole lot like adultery under the UCMJ. Further, Rivet lived in off-base military family housing at 1070 Valley Forge Court. The building itself looks to hold 6 separate residences. Given that this was military family housing, he was prohibited from just moving new people in. So Rivet and Brandy kept their romance a secret. They were both still midstream in the process of divorcing, and dealing with the challenges of child custody cases. To the outside world, Rivet professed Brandy was just his live-in nanny. Something he could, totally afford on his salary. On Monday, January 25th, 2010, Brandy brought all 4 children with her to pick up Rivet from work. It's not clear whether Brandy had base access through the husband she was separated from, or if Rivet caught a ride to the gate with colleagues or friends. But in order to actually drive all the way up to the USS Simpson, she would have needed a dependent ID. Brandy was struggling with the kids that Monday. She'd been frustrated with them that day and welcomed the relief of having another adult to tap in. Together, the quasi-Brady bunch returned home around 8 p.m. They put the children to bed around 30 minutes later. Brandy and Rivet retreated to the living room without the children, until Rivet went upstairs to look in on them around 9 p.m. From the puzzle pieces I found, Eddie, Brandy's 2-year-old son, shared a room with Rivet's 3-year-old daughter. The older children, presumably, shared the other room. When Rivet went upstairs around 9 p.m., Eddie was awake and crying, and Rivet set about putting him back to sleep. I found conflicting information on when Rivet went upstairs and for how long he was up there. So while I've done my best to parse out timelines, there may be slight inaccuracies. When Rivet hadn't returned, Brandy became curious and climbed the stairs to check in on them after hearing a loud thud. From outside the children's room, she heard Rivet telling Eddie, the 2-year-old, to go to sleep. Shortly thereafter, Rivet emerged. He said Eddie had woken up his daughter and that he was trying to get both of them to go back to sleep. Brandy didn't enter the room. Rivet was sweaty and he appeared overwhelmed. He sat on the top set of the stairs and put his head in his hands. He told Brandy he couldn't do this anymore. Brandy thought about what he told her and, in the context, believed he meant laying 2 children under 4 years old down for the night after a long day at work. She didn't think it was anything more serious than that. Brandy and Rivet went back downstairs to watch television. They stayed there for approximately an hour and a half before deciding to go to bed. They climbed the stairs, and Brandy went into the primary bedroom while Rivet checked on the children again. I don't have context here, whether this was the usual number of bed checks for Brandy and Rivet or who usually checked on the children in the evenings. But when Rivet entered the room, he called out for Brandy and told her to call 911. He said it looked like Eddie was having a seizure. Paramedics arrived at the home and life-flighted the toddler to the Pediatric Trauma Center at UF Health, Jacksonville. Eddie had suffered numerous injuries to his head and eyes that resulted in a fractured skull, blood on the brain, and a blown pupil. A blown pupil is when a pupil is fixed and dilated and doesn't constrict when exposed to light. Experts concluded that Eddie's injuries were too severe to be caused by an accidental fall. Given the severity of these injuries, Eddie would have been visibly symptomatic and would have had an immediately altered level of consciousness. Eddie wouldn't have been able to smile and talk and play and seem normal. It would have been very apparent that something was wrong. When Rivet entered the children's room at about 9 p.m., Eddie was awake and crying. Experts agreed that if that was true, Eddie's injuries had to happen sometime between when Rivet walked into the room to settle the children and when he checked back later and summoned emergency services. In spite of the care he received at UF Health Jacksonville, Eddie died at the Pediatric Trauma Center 4 days later, on January 29, 2010. I didn't find much on Eddie's father, Bert, but did uncover one news report that quoted Bert describing Eddie as a wonderful little child who was all about making others happy. When investigators talked with Rivet for the first time, he immediately lied about his relationship with Brandy. He maintained that she was a nanny that lived in the home and that they were not romantically involved. I would observe this. There were only so many bedrooms in the house. Unless there was some separate bedroom set up for Brandy, a bedroom she wasn't actually using while the children shared, it wouldn't take much for this statement to sound suspicious. This was not an easy investigation. The subject, the traumatic death of a child, is emotionally dense. But the biggest hurdle investigators faced was that it wasn't immediately clear what happened. Well, it was clear that someone beat Eddie. What was unclear was just who did it. There were 2 adults in the house, and hypothetical motives existed for each of them. Brandy was frustrated with the kids that day. Rivet was frustrated that Eddie woke his daughter, and that he had to put both back down for the night. Over the course of the next 3 years, investigators worked to piece together what happened in Rivet's home that night. Brandy blamed Rivet. Rivet blamed Brandy. Investigators diligently plugged away, but were slow to uncover answers. There are some allegations about Rivet signing away his parental rights to his first wife in the months that followed Eddie's death. That said, I cannot find anything official that backs this up. So as far as we're concerned, this is an unsubstantiated rumor that's floating around the internet. As you can probably imagine, Rivet and Brandy broke up. Later in 2010, after Eddie's death, Petty Officer Rivet met a woman named Andrea, and they began dating. They got married at the Duval County Courthouse on February 15, 2013. From what public records reveal, this was Andrea's second marriage as well. I believe her divorce was finalized sometime in 2011. Over the course of their marriage, Andrea and Nicholas have had 2 sons together. 2 months after the Rivets wed, on May 21, 2013, a judge finally considered the evidence of the extent of Eddie's injuries, the timeline for seeing symptoms, and evidence that Rivet was the last adult with Eddie before he showed symptoms of his extensive injuries. The judge found probable cause to approve the arrest warrant, and on May 22, 2013, the Jacksonville Sheriff's Office arrested Rivet. He was arraigned and denied bond. 3 years after the toddler's death, someone was finally in custody. Again, sources are fuzzy here, but from what I can put together, Rivet was still on active duty at the time of his arrest and was still stationed at Mayport. This is an interesting tidbit to me, in part because that means Rivet was at Mayport for at least 3.5 years, which feels a little long for the kind of permanent change of station schedule I am accustomed to. Over the next 2 years, prosecutors and defense counsel prepared to take this matter to trial. During voir dire, prosecutors and defense attorneys asked jurors about themselves and any potential ties to the case. They presented them with a list of witnesses and inquired whether the jurors knew anyone tied to the case. They selected their jury and proceeded to trial. Shortly after opening statements, a sailor on the jury came to the court with a concern. He realized he served on the same ship as one of the witnesses. Further, 2 additional witnesses were married to sailors that the juror worked with. It's unclear how much additional digging everyone did at this point, but they didn't call up their alternate, and that juror remained on the case. Over the course of the trial, Brandy and Rivet again pointed the finger at one another. Rivet's defense team sought to introduce evidence that Brandy, Eddie's mother, beat him as the culmination of her frustration with the children that day. Rivet's defense team put on evidence that Brandy used profanity in front of her children and lost her temper with them from time to time. Someone testified that Brandy once expressed to her friends that she had thoughts of harming herself and her children. Brandy herself testified at the trial and testified unequivocally that she did not harm Eddie. A week later, the trial concluded, and the jury went into deliberation. They were tasked with parsing through the evidence admitted over the course of the week, all of it circumstantial. They had to put together the puzzle pieces of what happened to young Eddie Robb when he went to bed on January 25, 2010. They had to determine whether the state made its case against Rivet sufficiently, and whether the evidence showed, beyond a reasonable doubt, that Rivet entered the room and beat his girlfriend's toddler. Ultimately, the Jacksonville jury convicted Rivet of second-degree murder on June 5, 2015. Months later, they sentenced him to life in prison on September 10, 2015. Rivet was credited 112 days for time served. He was ordered to pay $150 in restitution to the Victim Compensation Trust Fund for payments they'd made to Brandy, and an additional $666 in court fines and fees. 7 years ago, in March 2016, Andrea Rivet, Nicholas's second wife, opened a Change.org petition for clemency from the Florida governor. This is the first case I've covered that I've found such extensive written support from family and friends. Supporters range from Rivet's family to his high school baseball coach and fellow sailors. Many of the comments state that they do not believe Rivet to be capable of harming a child and raise concerns about the case being purely circumstantial. Eddie's maternal grandmother opened a counter-petition on Change.org in April 2016, advocating for denying clemency. Signatories to each petition are vehement in their beliefs and believe that they know what happened on the night of January 25, 2010. They believe that they know best who was responsible for the death of a young boy. There is one thing that signatories on both petitions agree on. Eddie Robb deserves justice. On appeal in Florida, Rivet raised a variety of issues. First, I'll discuss the issue of the potentially biased juror. Then I'll move into the arguments that I find far more interesting. 14 days after the jury convicted Rivet of second-degree murder, defense counsel filed to interview the juror who knew multiple witnesses in the case. They were entitled to do so within 10 days after the conviction, and they missed their window. But I would like to put this decision back in context. Defense counsel knew shortly after they made their opening statements that they had a potentially biased juror on their hands. They made a decision at that point in time to move forward. I would venture a guess, though I obviously have no way of knowing, that they thought if this juror was biased, it was going to be in their favor. A fellow sailor who might know or have heard that Rivet was a good guy, that he possessed all the traits the signatories on Change.org say he does. This feels like a very calculated risk. When the defense counsel filed the motion 4 days late and after knowing about the issue during trial, the trial court judge denied their motion as untimely without good cause. The appellate court could only evaluate this decision for abuse of discretion, and, finding none, the appellate court didn't delve any further into whether or not the juror was actually biased. The more interesting legal argument, to me, is the argument that the trial court should have granted Rivet's motion for acquittal because the evidence was entirely circumstantial. At trial, the court denied the motion. On appeal, the appellate court got to consider the issue de novo, or, put another way, the appellate court didn't have to give the trial court decision denying the motion any deference. This functionally mimics the military factual sufficiency review, which I am personally fascinated by. In Florida, the appellate court wrote, quote, "A criminal defendant is entitled to a judgment of acquittal if there is no direct evidence of guilt and if the circumstantial evidence does not exclude every reasonable hypothesis of innocence." That means if the circumstantial evidence does not prove guilt beyond a reasonable doubt, a defendant is entitled to be acquitted. And frankly, this is true in every jurisdiction. Guilt must always be proven beyond a reasonable doubt in a criminal trial. But Florida case law takes this a half step further, and specifically requires that in cases where the state's evidence is wholly circumstantial, there must not only be sufficient evidence establishing each element of the offense. The evidence must also exclude the defendant's reasonable hypothesis of innocence. This is a little nuanced, so let's break it down a little bit further. Circumstantial evidence is evidence that creates a logical inference that a fact exists. This is different than the direct observation of a fact. Circumstantial evidence requires the finder of fact to connect the dots. Sherlock Holmes is an expert with circumstantial evidence. Circumstantial evidence might allow for more than one explanation. Let's use episode 3, the Turner case, as an example. Prosecutors in the Turner case introduced circumstantial evidence from the downstairs neighbors. The downstairs neighbors heard 3 gunshots and screams from upstairs. Then they saw 2 people dressed in dark clothing running down the stairs and away from the building. There are a few explanations for the behavior they witnessed. The 2 people running from the building could be fleeing from gun violence, or they could have been the perpetrators, dressed for the occasion, running from the scene of a crime. The prosecutors in Turner also offered direct evidence. The victim testified that Malcolm and Anne Lynn Therese Turner confronted her in her home, that Malcolm shot her 3 times, and that Malcolm and Anne Lynn Therese ran away from her home. If the circumstantial evidence narrows the field to a couple of possible hypotheses, but doesn't prove one over the other beyond a reasonable doubt, Florida defendants are entitled to be acquitted. And that's the route that Rivet and his appellate team tried. They argued that the circumstantial evidence narrowed the truth down to 2 possible hypotheses. Either the state's hypothesis was right, and Rivet himself killed Eddie, or Rivet's hypothesis of innocence was correct, and Eddie's mother, Brandy, murdered the toddler. This argument made Rivet's appeal unique under the circumstantial evidence standard. Successful appeals under the circumstantial evidence standard in Florida had never named a specific identified person believed to have committed the crime. The appellate court's task was to unpick this tangled web and decide whether the evidence introduced at trial excluded the possibility that Brandy killed Eddie. The court concluded that the evidence on the record did exclude that possibility, namely that Rivet was the last one to interact with Eddie while he was alert and responsive, and that the specific identified person Rivet alleged to have committed the crime, Brandy, testified at the trial that she didn't hurt Eddie. Brandy's testimony put enough evidence on the record to defeat a motion for the judgment of acquittal, even under the circumstantial evidence standard. The trial judge, therefore, did not err in denying Rivet's motion for acquittal. Rivet's circumstantial evidence appeal failed. The outcome and reasoning from the court highlights where this Florida motion differs from the kind of factual sufficiency review I talked about in episode 7, the Wilson case. In Wilson, the appellate court took a deep dive into the credibility of witnesses while determining whether there was sufficient evidence to support a conviction. Here, the Florida appellate court noted that Brandy testified that she did not harm Eddie and that the jury believed her, concluding the circumstantial evidence was sufficient. They didn't do a deep dive into Brandy's reliability as a witness. But let's not get too bogged down by my fascination with factual insufficiency. Rivet further alleged in his appeal that the trial court erred by not admitting more evidence of Brandy's parenting into the record at trial. In order for this Florida State Appellate Court to find an error in the trial court's decision-making, the Court of Appeal had to determine whether the evidence of bad acts, the evidence that the trial court excluded, was sufficiently similar to the bad act at the heart of this case, the beating death of a toddler. If they were sufficiently similar, then the evidence should have been admitted. Rivet's appellate team brought witnesses to testify to Brandy's bad acts. One witness stated they had seen Brandy slap her older son in the head, and that it made him lose his balance. And, this first witness said, Brandy didn't show any emotion when Logan then began to cry. Another witness described Brandy losing her cool, yelling and cursing at other children, and that they had witnessed Brandy yank Eddie up by the armpit to get him off the ground. A third witness described seeing Brandy spank her children using either her hand or a hairbrush. These bad acts, the Court of Appeal determined, were too dissimilar to the violent acts that ultimately ended Eddie's life. I'm going to go into the injuries Eddie sustained with a little more detail. If you would prefer not to hear that, please skip ahead 15 seconds. Eddie received at least 3 very severe blows to the head. He was struck with such force that multiple areas of his skull bruised. These blows caused nerve damage to his brain and detached one of his retinas. These devastating injuries were not comparable to a spanking or to being pulled up from the ground. Though a witness testified to seeing Brandy slap the back of Logan's head, a slap was not the same kind of force required to bruise Eddie's skull. The Court of Appeal concluded that the severity of Brandy's prior bad acts was too dissimilar to the attack on Eddie, and that the trial court judge appropriately excluded this kind of testimony. Rivet's clemency appeal has thus far been unsuccessful, and he remains incarcerated at Graceville Correctional Facility, about 90 miles northwest of Tallahassee, near the Alabama border. Thank you for listening. If you enjoyed today's episode, please remember to subscribe and rate the podcast wherever you listen. I invite you to submit case suggestions and feedback to conductunbecomingpod@gmail.com. Join me next time when we take a look at the logistics of an international assault. Until then, take care. Conduct Unbecoming is a podcast where I get to talk about interesting crimes and cases that involve U.S. military service members. I research, write, and produce the podcast myself. The opinions expressed are my own, and perhaps it's obvious. Conduct Unbecoming is not approved, endorsed, or authorized by the Department of Defense.